Welcome to today's video where we break down important updates for the subclass 482 visa holders in Australia. If you're a 482 visa holder or thinking about applying, this video covers the latest visa policy changes, including your workplace rights and the new subclass 408 temporary work justice visa that makes the process smoother for applicants. First up, let's talk about the rights as a 482 visa holder. Just because you're a temporary visa holder doesn't mean you lose your workplace protections. Under both the Migration Act and the Fair Work Act, you have the same rights as any other employee in Australia. Here are some key obligations your employer must meet under these laws. They must pay you the same as any Australian employee doing the same job. You can only be asked to perform duties related to your approved occupation. They cannot make you pay for recruitment or sponsorship related costs. If your employer is breaking any of these rules, you can report them safely. In August 2024, the Australian government took further steps to protect visa holders from workplace exploitation by introducing the Workplace Justice Visa. This visa is part of temporary work, subclass 408 under the Australian government endorsed events. And it's designed to give temporary visa holders who are facing workplace exploitation the ability to remain in Australia and pursue their claims. The Workplace Justice Visa offers several key benefits. It allows you to stay in Australia while your workplace exploitation claim is being resolved. You can work unrestricted hours in any occupation with any employer or even be self-employed. And you can include family members in the visa application, so your loved ones don't need to leave Australia during this process. But what exactly qualifies as a workplace exploitation? Let's break it down. According to the government, the following actions can be considered as exploitation in the workplace. Underpayment or non-payment of wages, including missing superannuation and other workplace entitlements, threats to cancel your visa from your employer, demands for upfront payment or deposits just to secure a job, unlawful, unpaid or underpaid training or trials, misclassifying you as an independent contractor when you should be an employee, pressuring you to work more hours than your visa conditions allow, failing to comply with workplace health and safety standards, bullying or harassment, including sexual harassment, using coercion, undue influence, or misrepresentation in any work-related arrangements, discrimination or unfair dismissal. Another major update relates to the Fair Work Act. Starting from August 26, 2024, the new closing loopholes laws are in effect. These changes redefine protections for independent contractors, making it hard for employers to exploit workers under loopholes in the previous laws. This is a significant shift, ensuring fair treatment for all workers, including temporary visa holders. Now let's move on to the major update for the subclass 482 visa applicants, particularly those under the short-term stream. As of 2nd August 2024, the Genuine Temporary Entrant requirement has been simplified to make the application process more straightforward and applicant-friendly. The GTE requirement was originally put in place to ensure that visa holders intend to stay in Australia temporarily. The applicants had to actively prove that they were only in Australia for a short period and would leave after their visa expired. This required providing detailed documentation to demonstrate ties to their home country, like financial assets, family, and employment commitments abroad. Here's where the major changes come in. From August 2024, the policy assumes that you meet the GTE requirement unless there are specific concerns about your case. So the burden of proof has been lifted for applicants. You no longer need to actively prove that you're a genuine temporary entrant, which can save you time and reduce the stress of the application process. This change marks a shift in the GTE compliance process. Here's a breakdown of what's different. Simplified GTE compliance. You are now assumed to meet the GTE requirements by default unless the Department of Home Affairs identifies red flags. This means that unless there are specific reasons to doubt your temporary intent, your application is most likely to go through without complications. Reduced list of negative indicators. Previously, factors like holding multiple temporary visas or staying in Australia for extended periods could have been seen as non-compliant with the GTE requirement. Now, these factors are no longer automatically viewed as red flags. For instance, if you have held several 482 short term visas in the past, that's no longer a major concern in assessing your temporary intentions. Although these changes make it easier for applicants, the Department of Home Affairs still retains discretion. They may still flag your application if certain issues arise, like visa compliance and cancellation history. If you've had a visa cancelled in the past with some exceptions, or have not complied with previous visa conditions, this could still raise concerns. Inconsistent information, significant inconsistencies in your visa applications, like declaring different occupations or failing to provide accurate details across different applications, could be considered red flags. Multiple unsuccessful applications. If you've repeatedly applied for temporary skills shortage visa and withdrawn applications, or changed occupations multiple times, it may trigger further scrutiny. High risk applicant cohorts. The department uses data analysis and intelligence reports to flag applicants who may be part of high risk groups for non compliance or migration fraud. Immigration history. If you've faced immigration issues in Australia or other countries, such as visa refusals or breaches of immigration laws, these factors still weigh against you. So, what do these changes mean for you as a 482 visa applicant? In short, the streamlined GTE policy makes it easier to apply for the visa. The reduced burden of proof and fewer negative indicators mean that genuine applicants with a straightforward visa history can benefit from a smoother and quicker process. However, you still need to ensure that your application is consistent and free from any discrepancies. While the Department of Home Affairs has simplified the process, they can still assess each application on their own merits, particularly if red flags appear. In summary, these changes to both the workplace protections and visa policies are designed to protect 482 visa holders and make the application process more transparent and straightforward. If you're applying for the subclass 482 visa, you'll find the new GTE rules much easier to navigate, but you should still make sure your application is accurate and complete. If you require assistance or guidance with your skill migration pathways or any other immigration matter, connect with us using the contact details on screen. If you found this information valuable, make sure to like this video and subscribe to our channel for more updates on immigration policies and other insightful content. And don't forget to leave your thoughts and questions in the comments section below. We love hearing from you. Thanks for watching, and we'll see you in our next video.